Hi, I'm Amy Odom, and today I'm going to talk to you a little bit about a recent CCK victory in the case Laska versus McDonough. This case involved a statute 38 U.S.C. 1114 subsection T, which provides a special level of compensation for veterans with severe TBI, traumatic brain injury. And many decades ago, Congress enacted 38 U.S.C. 1114 subsection R, which provides the highest level of special monthly compensation to the most catastrophically disabled veterans. But in order to get to that level of special monthly compensation, the veteran needed to have, or still does need to have, severe physical injuries like loss of use of the legs or loss of use of the hands. Then came Operation Iraqi Freedom and Operation Enduring Freedom and the signature injury of traumatic brain injury. Of course, many veterans who served in other conflicts have suffered from TBI, but there wasn't a kind of national awakening to the incidence of combat-related brain injuries until OIF and OEF. And Congress realized that veterans with severe TBI may not also have the physical injuries that would qualify them for that high level of special monthly compensation provided in 38 U.S.C. 1114 subsection R. But nonetheless, those veterans' brain injuries are just as catastrophic as severe physical injuries, and they are also in need of a special monthly compensation. So in 2010, Congress enacted 1114 subsection R, which gave veterans with TBI a path to the highest level of special monthly compensation based on brain injuries alone. To qualify, veterans must have, 1, a service-connected TBI, which 2, renders the veteran in need of aid and assistance from another person, and 3, without that aid and assistance, the veteran would need to be institutionalized, like in a hospital or some other kind of care facility. However, through regulation, VA created a 4th requirement, that the veteran needed to be in need of not just aid and assistance from another person, but in need of a higher level of care. And VA defines higher level of care as things such as physical therapy, administration of injections, placement of indwelling catheters, and other functions that require a professional healthcare person or the regular supervision of a trained healthcare professional. These are not the kinds of things that veterans with TBI need assistance with. So in Laska versus McDonough, CCK took VA to court and argued that the regulation was invalid because it was inconsistent with the plain language of the statute, which does not require this 4th element of a need for a higher level of care. We also argued that it was inconsistent with the statute's legislative history, which demonstrated that Congress wanted veterans to be compensated for the need to be supervised by someone so they don't do things like get lost in familiar places, which is the thing that is common in veterans with very severe traumatic brain injuries. Well, the Veterans Court agreed, and it struck down the regulation that required this 4th element of a higher level of care as invalid. VA must now award special monthly compensation at the T rate, which is a very high rate of compensation, to veterans with severe TBI without requiring that they also show that they need a higher level of care. They only need to show that they need regular aid and assistance of another, without which they need to be hospitalized or be put in some other kind of care facility. This is what Congress intended, and we are proud to have had a part in making sure that Congress's intent is realized. Be sure to like and subscribe, and for more information, check out our website, cck-law.com.